The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, and welcome to Cooke and Hutchinson Lawyers Estate Planning Essentials for Advisors. I'm conscious of the fact that we've said this will be no more than an hour and want to finish by 1:30, so we may end up quicker than that, we may not. So everyone's not quite here yet, but we'll start nonetheless and they can catch up as we work our way through. That's me, Dan Hutchinson. We won't concentrate on that for too long, but these slides will be emailed out to you as well. That's who I am and a short bit of information about me. If you wanted more information about my bio, what I'm about, you can go to our website and follow the links there, cookehutchinson.com.au. A disclaimer, as per usual, as you'd expect from a law firm, it is general advice today. If there's something specific that you'd like to talk to me about or one of the other solicitors here about, we're more than willing to have a chat to you on the phone or to answer any questions that you might want to send us by email. Before I go through the topics for today, just some quick housekeeping. If you have any questions, please ask them and I'll do my best to answer those. If I answer your question or you don't think that I answer your question particularly well, then please let me know and I'll make sure that I endeavour to give you a more in-depth answer. So the two things that we're going to concentrate on today is why your client should always have a corporate trustee of their self-managed superannuation fund. All of us refer to those as SMSFs. And also, the second topic then is the importance of binding non-lapsing death benefit nominations. The two topics go hand in hand and there is some overlap. So to begin, our reasons for recommending a corporate trustee over individual trustees. First is to avoid intermingling of assets. The second is the limitation of liability for trustees in a corporate structure as opposed to on an individual basis, avoiding the cost of the re-registration of assets when trustees change for estate planning purposes, the ability to have a true single member fund, and to limit exposure to the new penalty provisions, which, as you'll see, are perhaps not so new. The first part, though, avoiding intermingling of assets. So, or why should assets not be intermingled? And I guess to clarify, when I talk about intermingling assets, I'm talking about situations in which the individuals, Mr. and Mrs. Smith, own their house and their bank accounts, but they also have an account that they are trustee of as their for their self-managed superannuation fund, and they might use that in a manner that perhaps they shouldn't, which of course is a no-no. Section 52 of the Superannuation Industry Supervision Act, or just called the SIS Act, requires the trust deed to provide a covenant that the assets in the SMSF will be kept separate from the personal assets of the members. So where the assets are intermingled, there is a contravention. That contravention then can cause problems. So where the fund has individual trustees, the assets must be registered in the names of all of the trustees, no exceptions. So of course for the self-managed superannuation fund, the members must be trustees and the trustees must be members. There are numerous cases and things that come across our desk where for convenience at the time of purchase, or perhaps inconvenience because a trustee is unavailable, an asset isn't purchased in the name of all of the trustees. That then causes there to be a contravention of Section 52 of the Act and can cause some issues. It becomes more difficult to prove compliance with the terms of the deed where you have individuals and they're perhaps utilising those SMSF assets as their own, or as if they are their own rather than belonging to that particular self-managed superannuation fund. This will likely, as I've alluded to already, cause a audit contravention report to be issued, and the pundits say approximately 33% of those contravention reports are for failing to observe Section 52 of the Act. So that is the simple task of keeping your self-managed super fund assets separate to your own personal assets. The Corporate Trustee allows for the use of Section 127 of the Corporations Act when purchasing assets, so 2 directors need to sign. It also makes it easy to comply with, or to prove compliance with, Section 52 of the Act. That is, that it's held by Smith Superannuation Benefits as trustee of the Smith Self-Managed Superannuation Fund, rather than the name of Bob and Joan Smith. I hope that sometimes that also changes the client's mindsets a little bit, and perhaps only sometimes, but if they're actually looking at an account that's in a corporate name rather than in their own name, it's less likely at least that they will be confused by it. Our next reason that we've been speaking about, or want to speak about, is limited liability. The self-managed super fund assets are obviously separate to personal assets, and they're supposed to be kept separate, as we've just discussed. The assets that are kept separate are then protected from bankruptcy and against other personal claims. They do not form part of the bankrupt's estate the same way that they do not necessarily form part of a deceased estate. The assets are quarantined. The member who might go bankrupt is merely a member or a beneficiary of a fund. They do not have the legal title to those assets. The legal title instead rests with the trustee. Now, that distinction is still true in relation to individuals acting as trustees, but they must prove that those assets are separate, and it's a much more difficult conversation to have with the trustee in bankruptcy, particularly where Mr. Smith has been dipping into his own self-managed super fund assets and has been intermingling them. It could then also expose him. So it's just easier to be able to prove that limited liability in relation to either a trustee in bankruptcy or somebody trying to enforce a judgment debt. Limited liability then continued. Individual trustees are personally liable for the actions of their co-trustees, and that's something that's not widely known, and certainly something that we want to get out there. The directors, however, are not strictly liable for the actions of their fellow directors, especially where those directors have committed some sort of fraud on a frolic of their own. And rather than just continuing to sort of drone on with theory, I thought it'd be a good idea to try and illustrate that point. In Shale, which is the first case that's mentioned there on the slide, the ATO obtained judgment against an individual trustee who was one of 2 individual trustees of a self-managed super fund. One of the trustees misappropriated the funds without the knowledge of the other and then absconded, presuming to a non-extradition country. The result was that the trustee who could be located was liable for a very significant tax bill and had no resources to fund that liability. The result of the actions of the trustee who absconded resulted in the ATO declaring the self-managed super fund as non-compliant, the result of which was the fund incurred a tax liability of just over $1.5 million. There were additional compliance penalties of nearly a further $1.5 million, $1.475 million. Now, it's important to note that there was absolutely no dispute in this case about the fact that the remaining trustee had no knowledge and didn't consent to the actions of the trustee who absconded. The poor trustee who was left facing the tribunal argued that the fund should not be made non-compliant because of the significant tax consequence that would result. And the tribunal found that although it was certainly not difficult to feel sympathy for the position of the remaining trustee, the tax and assessment penalties should be upheld for policy reasons. And look, this situation wouldn't have been as dire if the company had been a trustee. The remaining trustee was personally liable for the fund's tax liability, even though the liability arose from events which she had no knowledge or involvement in, and that wouldn't have been the case if this was a corporate entity. And I guess just to prove that that isn't an isolated case, the decision of Triway, which I'll go into in less detail, a similar situation arose in that case where the trustee just happened to be a drug addict's son who withdrew almost all of the money from the self-managed superannuation fund. And although the tribunal again expressed sympathy for the other trustee, who was no doubt trying to help out the son, it upheld the notice of non-compliance, the effect of which was that the other trustee remained individually liable for the tax assessment with no resources from which to pay that assessment, and presumably they declared themselves bankrupt. So they're two illustrations. I believe from memory the first situation was one in which a husband absconded with a mistress overseas. The second was where somebody obviously trying to help out their son admitted him as a member of the fund, and as a result of the admission to that fund, then found themselves liable for the actions of that son in basically depleting or robbing them of their self-managed super fund assets. So we talk about then the re-registration of assets, which is another issue. Now, there are some limited exceptions which I won't go into now in Section 17 capital A of the SIS Act, but subject to those exceptions, all trustees have to be members of the fund and all members of the fund have to be trustees. I would have mentioned that earlier. Where the membership of the fund changes, all fund assets need to be re-registered. So in the situation of Bob and Joan Smith, if, for instance, they had, perhaps a third trustee, their daughter Jane, and Jane decided, look, Mum and Dad, your objectives are different to mine. I'm not going to be a member of this fund anymore. I'm going to start my own self-managed fund. All of the bank accounts, the managed funds, the publicly listed shares, the real property will all need to be transferred over into the names of just Bob and Joan Smith. You can't leave Jane's name on there. If you do that, then there are non-compliance issues. If, for instance, however, it was Smith Superannuation Benefits as trustee, the corporate trustee details need only be updated, and they need only be updated within 28 days of the change by lodgement of a correctly completed Form 484. Depending on whether you're registered and you have corporate keys, I believe those now can be lodged as an online lodgement to ASIC. So it's simply a matter of saying that Jane's no longer a director and she's no longer a shareholder of the corporate trustee, rather than having to contact any number of banks, any number of different share registries, and also perhaps lodging transfers with the titles office in whatever state. So the corporate trustee not having to attend a re-registration, it's certainly a feature that is, I believe, helpful. From an estate planning point of view, of course, when an individual dies, they exit the fund. So if they exit the fund, if Bob passes away, which is normally the case, we fall off our perch first normally, and Joan's left, and she is the only surviving member of the fund, and it is a corporate trustee, then all that needs to happen is that ASIC has to be notified of the fact that Bob is no longer a shareholder and he is no longer a director. An individual cannot act as trustee alone. So if, for instance, Bob and Joan were the individual trustees, there is then a short period of time in which Joan needs to bring somebody else in to act as trustee with her. So that other person can't be an employer unless they're a relative, and must be appointed to act as co-trustee. So that co-trustee can only be paid in very limited circumstances. So just have a think about what we've said previously. If the individual trustee assumes the liability of their co-trustee, and this person is then brought in to be co-trustee with Joan and has for no discernible benefit, they can't be paid, why would they volunteer to do it? Unless, of course, they didn't know what the risks were. But effectively, you're asking somebody, on the one hand, to sign up to act as a trustee and to be jointly and severally liable for any action that you take. You are then jointly and severally liable for any action that that person takes, and they have some control over what is effectively your superannuation. It just doesn't make sense to me why people would do that, particularly when the corporate trustee has perpetual succession and the shares in the self-managed super fund trustee form part of an estate and can be used as part of an estate plan if need be, and they would only be used in conjunction with a binding non-lapsing death benefit nomination, which we'll speak about soon. There's no need to appoint another party as co-trustee. As I've said, Joan just continues on as a sole director, sole shareholder, has total autonomy and isn't liable for anyone's actions other than her own. Probably already spoken about this really in terms of the ability to have a single member fund, but it is only you're only able to do this if you have a corporate trustee. Individuals cannot act as a trustee on their own. So individual trustees or the surviving spouse is then required to find somebody who they trust, because the assets are required to be re-registered into both of their names, both the surviving trustee and the new trustee. The new trustee exerts control over the assets, even at a time when the surviving trustee, who is also the only member of the fund, has diminished capacity. And the new trustee will then have control over the self-managed superannuation fund when the surviving member passes. That's particularly important, and we'll deal with a situation in relation to that when we talk about binding death benefit nominations, or a situation that might arise there. That it's obviously subject to a binding death benefit nomination, hopefully a binding non-lapsing nomination. You talk about the new penalty provisions. They're not all that new. If you didn't know, on the 1st of July, the ATO decided that they were then allowed to impose administrative penalties for non-compliance. Those range from $850 to $10,200 per breach. $850 is nothing to be sneezed at. $10,200 is more of a disaster. Where there are individual trustees, the scope for compliance breaches is far greater in our view, because there is, you talk about re-registration and all of those other issues that we've spoken about. It's more complicated. There are more things that can go wrong. There are more moving parts. Individual trustees, as we said, are liable for the actions of their co-trustees. So in this example, we have a happy family, 4-member fund, 4 trustees, and there's a $10,200 penalty breach. That notice is issued by the ATO. It'll be issued to each of them. So the penalty will be $40,800. The same 4-member fund with a corporate trustee for the same breach will have one penalty applied of $10,200. So hopefully there's no breach, but if there was one, there's 30,600 reasons why you'd want to have a corporate trustee rather than an individual. So that, I guess, ends why we think a corporate trustee is a better idea than individuals. I note that, individuals, it's far simpler. At least in the initial stages of setting it up, you don't have to worry about setting up a company. There are no ASIC fees, there's no review fees, but just keep in mind that where it's a special purpose corporate trustee, the ASIC fee, the ongoing ASIC fees are about $45 rather than $216 or $218 or whatever a renewal is for a ordinary company. And look, a sole purpose self-managed super fund trustee is probably a pretty good idea for your clients and something that should be recommended. If that's something that you think would benefit your clients and you need a deed of resignation and appointment of trustee can be prepared and a corporate trustee put in place after the event. So if there are people that you can think of that need that done, they should be making arrangements for that to happen, in my view at least. If we can be of assistance, of course, we'd love to help, but if not, at least if more people become a bit savvy about this and are able to appoint corporate trustees and avoid some of the risks that I've spoken about, then our job here is done. So binding non-lapsing death benefit nominations, and I think the very important part of all of this is sorry, that's not a very good colour if I've got red up there, is this part, this non-lapsing part. That's the big part of it. Yes, binding is important. I think non-lapsing is possibly equally as important. So to deal with that, why should they be binding? Why should they be non-lapsing? What happens if there's no nomination? What happens if the client can't make a non-lapsing nomination? And what are the requirements? That'll just be a refresher for all you people that obviously already know about all of this. So the central theme has been that the assets in the self-managed super fund are held by a trustee for the benefit of the members, and we've been talking about who the trustee should be and why. The legal ownership, of course, rests with the trustee of the fund, and the member should be able to leave their non-estate assets to their intended beneficiaries. So that's the other important point. These are non-estate assets. They're not assets that will form part of the estate. So while the client might have a will, they might necessarily have a binding death benefit nomination. There are a lot of reasons why you want to keep your superannuation assets out of your estate, and I'll deal with those a little bit later on. My question is, though, if that nomination is not binding, then what's the point? Why are we doing it? If the trustee can do whatever they want to do. And look, just to highlight that and to show you that, again, this isn't just somebody sprouting theory at you, there are real life examples. There was a decision in 2005 of Katz and Grossman, and it was heard in the New South Wales Supreme Court. So having no nomination or a non-binding nomination could lead to a situation like that. So what happened in that decision is the deceased left a non-binding death benefit nomination that indicated that he wanted to leave the proceeds of his self-managed superannuation fund equally between his two children, a son and a daughter. Okay, everything's fine there. He's made the nomination. Unfortunately for his son, the daughter completed an application for admission as a member of the fund, which was accepted. She was appointed as a member and necessarily then appointed as a trustee or the director of the trustee. I'm not certain which from memory. But upon his death, the daughter, in compliance with the relevant legislation, appointed her husband as an additional trustee. So that would tell me that they were individual trustees, and here's another reason why you should have a corporate trustee. The trustees then as allowed by the self-managed fund, refused to follow the non-binding nomination, which was a nomination that the benefits of the fund of $1 million be paid equally between the children. Instead, the daughter paid the entire benefit to herself, with her husband exercised their discretion as allowed pursuant to the terms of the deed. The son wasn't happy about that, as you wouldn't be, and he brought an application to have that decision set aside. That challenge was unsuccessful because the nomination was non-binding. The trustee daughter had been validly admitted as a member of the fund. She was able, with her husband, to exercise their discretion in the manner in which she had, pursuant to the terms of the deed. And just to add insult to injury, because the superannuation benefits came from a self-managed super fund, there was no recourse to the Superannuation Complaints Tribunal, although I don't know whether or not that would have done any better in any event than what the decision that the Supreme Court made. So that is just a result of an issue that isn't really necessarily a corporate trustee issue, but things could have been dealt with in a better fashion. For instance, the shares could have been left equally between the son and the daughter, thereby giving the son equal rights to appoint a director, and it'd be more likely then that the non-binding nomination would have been followed. The other thing that he could have done to circumvent all of that, notwithstanding my plea that people have corporate trustees from earlier, is he would have made a binding nomination. It simply would have had to have been followed. The next part then is, why should it be non-lapsing? Well, in my view at least, it's human nature that we set and forget. We've done that. We've been to see the lawyer. We've sorted that out. We've been to see our financial planner, our accountant, whoever, and look, we're done. We're finished. We've made our nomination. If it lapses and people aren't made aware that they lapse, then we go back to a non-binding nomination situation. It's important to note that not all funds will allow a non-lapsing nomination. There are some industry and other funds that won't. I believe Q Super's one, LG Super's another. And some argue that lapsing nominations that require renewal every 3 years are better for estate planning reasons. There aren't too many clients of mine that come in every 3 years to do their estate plan. They get a letter at least every 2 years to remind them to have a look at it. But look, it'd probably be 2 in 10 that actually take up that advice. There is a risk involved in a non-lapsing nomination because divorce won't revoke the nomination. However, in my view, superannuation, or in my experience, I'm not a family lawyer, but it's normally dealt with as an asset in the matrimonial pool of assets in a divorce and property settlement. Any friend of mine that's ever been divorced has certainly had their super dealt with. Any client that's come in to see me who's recently been divorced has told me about how they've either inherited a whole or received rather than inherited a whole host of superannuation assets, or have recently lost them as a result of a divorce. On balance, I think that a nomination that won't lapse is definitely your best course, because if it lapses, you get back to a non-binding nomination and your wishes aren't necessarily going to be carried out. So if there's no nomination, the trustee, and this is scary, interprets the terms of the deed. So they'll work out, well, what do we think it says? How do we think it should be applied? The trustee can exercise discretion to pay the proceeds to themselves. So we're talking about a Katz and Grossman situation again. And if there's no nomination, the super may be paid to the estate. Now, as I said before, payment to the estate is not always the best outcome. There's issue in relation to the tax treatment, in that if you can get assets into a testamentary trust, then obviously there are some major advantages there. There is an issue in relation to family provision claims. Now, not so much in New South Wales, where they have notional estates, and really the super will end up being dragged into the notional estate in any event. The bigger issue is in relation to the manner in which things can be kept apart in Queensland. They can be kept apart in Queensland and the claim can be avoided because it's not an estate asset. There's accredited situations, and then there are other individualised situations that might arise. I'm aware of the fact that I said that I'd finish at 1:30, and I'll just continue to push on here. We don't have a great deal of great number of slides left, so perhaps at the end here, just have a think about whether or not you've got any questions that you do want me to answer at the end. If you can ask those, we'll just put them into your box there. You should have a control screen. I can then answer any questions that you have. So if a client can't make a non-lapsing nomination, as advisors to our clients, whether you're an accountant, a financial planner or a lawyer, you should update and follow that up periodically. That's probably the only option that you've got. The client should also consider amending their enduring power of attorney to make it clear that they're allowing their attorney to confirm but not change the nomination that they've already made. What that will do will allow them the attorney to confirm that nomination. Now, there's some grey area in the Powers of Attorney Act in which some will say, look, the attorney quite obviously has the ability to be able to confirm that nomination. Others say, well, no, they don't, because they're acting in a they're not able to do that. It's even though it's a financial decision, it's being made to, or the decision or the confirmation is being sent to a trustee, so it's different. I don't think it is any different. But where the clients are in a retail fund or an industry fund that allows a binding nomination, or doesn't allow a binding nomination rather, then having that bit of extra in the enduring power of attorney really will help. The other thing the client might consider doing is switching funds, particularly if there's another fund that is able or will allow a non-lapsing nomination and the performance is similar. If the fund is a self-managed super fund, then the deed needs to be updated urgently because it is probably horribly out of date. I haven't seen a self-managed super fund deed in a number of years, in many years, that doesn't allow a non-binding nomination. So the requirements, I guess a refresher. The nomination has to be in writing. It has to say that it's a binding nomination. It has to nominate a spouse, a dependent or an estate as a beneficiary. And when we talk about dependent, we're talking about a tax dependent as defined in the Income Tax Assessment Act. It has to be signed in the presence of two independent witnesses who are over the age of 18. Very similar requirement to a will, and in many respects it really is. It's almost a superannuation will. Some lawyers are quite savvy, and they will call binding death benefit nomination something else to say that it's a superannuation will or similar. All that is a binding non-lapsing nomination, and it has to comply with the specific requirements that are set out in the deed. There are some deeds that say that it has to be in a certain form. There are other deeds that will say that the trustee must first resolve to accept binding non-lapsing nominations before that nomination can be made. The deed needs to be read, particularly if it is a self-managed superannuation fund deed and it is not a pro forma document being downloaded from AMP, MLC, Suncorp, whoever. If it's a self-managed fund deed, the advisor needs to look at what the specific requirements are, because if those requirements aren't followed and the decision of the trustee is challenged, for instance, somebody's not happy with the binding nomination, asks when the trustee resolved to allow or to accept non-binding or binding non-lapsing nominations, and the trustee can't say when it allowed that, then that nomination may well become non-binding, and that could lead to obviously other consequences. Thank you. That was a tad shorter than I anticipated that it would be, but I guess a quick webinar's a good webinar in a lot of ways. If anyone has any questions, they could send those through now. We don't seem to have any there. Look, if you want to send me a question about anything that I've spoken about today, please don't hesitate to contact me. My details are there on the screen now, so you could have a look at that. Obviously, you can just follow the link there down at cookehutchinson.com.au. Everyone that's attended today will get a copy of the slides that we've dealt with today and covers the issues that we've dealt with today. If you want any more information, there are a couple of articles that are up on our website in our blog. One relates to individual versus corporate trustees, and the others in relation to why a binding death benefit nomination is an important tool. Please feel free to go and have a look at that as well, and download and use those as you need. If you have any clients that you think perhaps we could help, then obviously we'd be more than willing to discuss that with you. And if you have any questions that are a Dorothy Dix type question or a hypothetical, then again, please don't hesitate to either give me a call or telephone me. I'll be only too happy to assist. This is the first of a series of webinars that we're going to put on. So if you have any suggestions about things that you'd like to hear about in the future, then please send those through to me as well. So that ends our webinar for today. Some more contact details for you. Thank you very much, everyone, for your attendance, and I wish you well for what is left of your Wednesday. Thank you.